Swayam Prabha. Digital India. Educated India.
Hello friends, welcome to the 13th lecture of our course on law of copyright, patent, trademark and other IP. This lecture is on infringement of patent, defenses and remedies. As we have already finished the substantive aspect of patent law as to what is invention, what are the criteria for getting patent, what are not considered as inventions. And then the second part was procedure, which I divided into two parts, lecture number 11 and lecture number 12. These two parts were on procedure, where we understood what are the stages in the patent process, from filing of patent application to publication to examination, opposition. And now the third part of patent law, which may be called as patent litigation, as to what happens when grant is given. What do we mean by patent grant? What rights come along with patent grants? What are the situations when we can say that these rights have been infringed? What are the methods to determine, tests to determine infringement of patent rights? Once infringement is established, what are the defenses available to the defendant? How will he contest the case of infringement? What exemptions does he have? And if he fails to establish any of the defenses, any of the exemptions, then what are the remedies available for the patent holder in case infringement is proved? This is what we are going to discuss in this session. So, we will start with infringement of patent first of all, but to understand infringement of patent, we will have to understand what are the rights of a patentee. Section 48 of the Act talks about rights of patentees. Now, if you recall, when we were discussing section 14 of Copyright Act 1957, I mentioned that the rights granted in section 14 are subject to other provisions of the Act. Same is the language used here in section 48 of Patent Act. The rights granted are subject to other provisions of this Act. A similar provision can be found in section 28 of Protection of Plant Varieties and Farmers' Rights Act. We will have a full session, full lecture on Protection of Plant Varieties and Farmers' Rights Act. I will refer to section 28 there. What I am trying to say is, in all these IP legislations, the right conferring provisions are subject to all other provisions. So, right conferring provisions are therefore least important provisions in any IP legislation. 48 goes beyond that. 48 says that rights are subject to other provisions, so other provisions are more important. Other provisions which include defenses are more important as compared to rights, point number one. Two, it also says that these rights are specifically subject to section 47. 47 identifies a small list of exemptions, and since 48 is specifically made subject to section 47, 47 gives me very strong defenses. So, subject to other provisions of this Act, section 48 confers rights on patentees, and there are two parts. If you see, if the subject matter of patent is a product, what are the rights? If the subject matter of the patent is process, what are the rights? In the first part, 48 says where the subject matter of the patent is a product, the exclusive right to prevent third parties who do not have his consent from act of making, using, offering for sale, selling or importing for those purposes that product in India. So these are the activities which are restricted activities for people other than patent holders. Let me tell you that patent rights are negative rights. Patent rights are negative rights. These rights do not authorize patent holder to start manufacturing the patented product. What patent holder gets? He gets exclusive right to prevent others from doing these activities. These only allow you to stop others from doing these activities. And what are the activities which you can stop? What are the prohibited activities for others? Nobody can make the patented product. Nobody can use the patented product. Nobody can offer for selling the patented product, or nobody can import a patented product. These are the activities which only the owner of patent rights, after getting appropriate approval, can do. So these are essentially negative rights. These are the rights in a situation where the subject matter of patent is a product. The second clause is rights when the subject matter of patent is a process. And what are the rights? The exclusive right to prevent third parties who do not have his consent from act of using that process, and from the act of using, offering for sale, selling, importing the product obtained directly by that process in India. So try and understand, when your invention is a product, when your patent is a product patent, you can stop others from making, using, offering for sale, selling, importing the patented product. When it is a process, there are two sets of rights which you have. One is you can stop others from using that patented process. Second, you can stop others from using, offering for sale, selling, importing what? Products which are obtained directly by the patented process. These are the rights which are granted to the holder of patent. And what is infringement? If someone is exercising any one of these rights without holder's consent within the territory of India, it amounts to infringement. Within the territory of India, try and understand, IP laws are territorial in nature. IP rights are territorial in nature. So my IP law, my Patent Act is good within territory of India. So it stops you from doing one of these activities within territory of India. Now, if you recall, while discussing copyright law, I referred to section 51 of Copyright Act 1957, which gives me instances of infringement. Section 51 of Copyright Act does not define infringement, it gives me instances of infringement. Unlike Copyright Act, we don't have a provision here in Patent Act which gives me instances of patent infringement. A general meaning will be useful here. The general meaning is, my rights are violated, my rights are infringed if somebody else is performing one of the activities which are prohibited activities, and those activities are there in section 14. I hope this is clear. Determination of infringement is a question of fact as well as question of law. And the important point here is that the onus is on the plaintiff to prove two things. One, he has to prove patent in his favor, this is one. And two, he has to prove that act of defendant is infringement. So these are the two things which the patent holder has to prove. Unlike Copyright Act, again I'll tell you, in Copyright Act, or for that matter we'll discuss Trademarks Act after maybe next session, in both of these there is a presumption in favor of validity of IP. You see, in Trademark Act there is a presumption in favor of validity of trademark. A registered trademark is presumed to be valid. The same is not true in case of patents. A granted patent, even a granted patent is not presumed to be valid. So therefore, when a plaintiff files a case of infringement, the first thing he has to do is to prove a patent in his favor, because otherwise there is no presumption. So once he will prove patent in his favor, then only he can go on to examine the act of the defendant and prove that act of defendant amounts to infringement of patent rights. Entire process of infringement proceeding, what is the role of court? The role of court is to construe the claim. This is very important. I will refer to this word claim again. So what I am trying to say, there are rights given in section 48. Nobody should exercise these rights without the authorization of patent holder. If somebody is exercising these rights, he is committing infringement of patent rights. What plaintiff has to do? He has to prove a valid patent in his favor, and he has to prove act of infringement done by the defendant. I said, what is the role of court? Court's role is to examine or construe the claim. I already mentioned in the previous class that in every patent application, claims part is the most important part, because patent claims is the part which determines the scope of monopoly. Out of the entire description which is there in specification, what is that part which is claimed by the patent holder? What is that which belongs to the inventor? What is that which is created by the inventor? That is to be found in the claims part. So claim delimits the scope of monopoly. Claim tells me the scope of monopoly. Since claim in a patent specification is the principal component to determine scope of monopoly, the main issue in a case of infringement is claim construction. You see, whether my patent has been infringed or not, whether my patent has been infringed by your product or not, will be determined by interpreting my claim to see whether your product is similar to something which I have claimed. What belongs to me is to be found in the part which is called as claims. So the main function of court in infringement proceeding is claim construction, and while construing the claim, the court has to keep in mind two competing claims, and court has to balance these two competing claims. One is interest of the inventor, the other is interest of the public. So keeping these two competing ideas, and in order to balance these two competing ideas, court has to construe the claims so as to decide the cases of infringement. Infringement can be actual, you see, infringement can be actual. Infringement can be threatened. Somebody is threatening that he will commit infringement of my patent rights. If somebody is only threatening that he may be committing infringement of my patent rights, the only remedy I have is to request the court to stop him from threatening me. That is the only remedy, is injunction. Whereas in actual infringement, there are more remedies. You can request for injunction, you can compel the defendant to stop the infringing activities, you can claim damages, you can claim something called as account of profit. We'll talk about these remedies towards the end of today's lecture. Actual infringement can be of two kinds, literal infringement, and second is infringement by equivalence. So first kind of actual infringement is literal infringement. The second kind of actual infringement is infringement by equivalence. Let us understand these two. We have understood what are the rights. We understood that these rights can be performed only by the holder of patent. If somebody else is performing without his consent, without his permission, he is committing infringement. We understand that the patent holder will have to prove a valid patent in his favor, will have to prove that the act of defendant is infringing. We have understood that the claims are the most important aspect of any patent specification in determining the scope of monopoly. So what is the role of court in the entire process of patent proceeding? The role is to interpret the claim. There are two kinds of infringement, actual, threatened. Actual can be of two kinds, literal, equivalence. Let us see what are these two. Literal infringement is a product is said to be literally infringing if all elements of a patent claim are present in the product, and a process is said to be literally infringing if all steps of a patent claim are present in the process. Now, what I am trying to say, I may have 3 claims in my patent. If my patent is a product patent and all the elements of any one of these 3 claims, a product will have elements, a process will have steps. So, if my patent is a product patent, all the elements in any one claim, if all the elements in any one claim are found in defendant's product, my claim, that particular claim is literally infringed. Similarly, if my patent is a process patent and all the steps of any process are found in defendant's process, then defendant's process is infringing of that particular claim. This is literal infringement where all the elements are present in defendant's product, where all the steps in one claim of plaintiff are present in defendant's product. This is literal infringement. This is literally infringing. A case will be a case other than literal infringement if there is a variant. If all the elements in patent claim are not same as defendant's product, or if all the steps in a patent claim are not same as defendant's process, that is the case of a kind of infringement other than literal infringement. There is a variation. Now, what do we mean by infringement by equivalence? We have to decide the nature of this variant. Defendant's product has something different from what is there in plaintiff's claim. What is that thing which is different? And there we use the second kind of infringement called as infringement by equivalence. So, I hope you understand what is literal infringement. Defendant's product is literally infringing of plaintiff's claim if all the elements of defendant's product is to be found in one of the claims of plaintiff. Now, if you see here, if elements in the defendant's product are different, if there is a variant, there are few elements which are different. For example, if I make a table with rectangular top, you made a table with circular top, there is a variant. Both the tables have top, but your top is circular, my top is rectangular. This is a variant. So, this is not a case of literal infringement. I cannot say that you have literally infringed my patent right. But then the variant in substance equivalent to the plaintiff's product. You have a circular top or a rectangular top, the fact of the matter is it remains a table which does the same function in the same way. So, despite having variant, there is no change, and the variant is nothing but equivalent of plaintiff's product. You understand? So, if elements in the product, defendant's product, that differ from patent claim are nothing but in substance equivalent to the elements in the patent claim, it is a case of infringement by equivalence. May have a different chair which looks different, there are variants, but in pith and marrow, the two chairs are same. Your chair is nothing but an equivalent of my chair. It has been copied except that there is minor variant. And that minor variant does not change the way the invention works, chair remains the chair. Such a case is called as infringement by equivalence. We have a case called as Ravi Kamal Bali versus Kalatek and others 2008, you see. Ravi Kamal Bali versus Kalatek and others 2008, where court has explained the meaning of equivalence. Court says equivalence means similarity in construction and function. Patented product, defendant's product, if two are similar in terms of function, if two are similar in terms of construction, that is, the two products are doing the same work in the same way to produce same result, it is nothing but an equivalent. This is how we establish the cases of infringement by equivalence. How do we determine infringement? There are 3 steps. Step 1 is called as claim construction. Claim construction, we are interpreting the claim of plaintiff. And how we are interpreting? What do we achieve by interpreting the claim of plaintiff? We try to understand the scope of the invention. And how do we interpret? Because you see, I have to establish similarity between plaintiff's product and defendant's product. How do I do that? By interpreting what is plaintiff's product. And how do I understand what is plaintiff's product? By interpreting his claims. So, interpretation of claims will tell me as to what is that which the plaintiff owns. And then I will compare the claim, the interpreted, construed claim with defendant's product to see whether it is infringement or not. I hope you understand what is literal infringement, infringement by equivalence. Infringement by equivalence is a situation where there may be variant in defendant's product, but the defendant's product is nothing but an equivalent of plaintiff's product. The variant is insignificant. Despite having that variant, the defendant's product is same as plaintiff's product. It is doing the same thing in the same manner to produce the same result. It is a case of infringement by equivalence. That means the pith and marrow of my invention has been copied. How do we determine infringement? The first step I said, construe plaintiff's claim to understand the scope of protection. How do we construe the claim? We have to identify the elements, we have to identify all the steps in plaintiff's process, plaintiff's product. When I am talking about elements, I mean we are dealing with product patent. When I am talking about steps, we are dealing with process patent. So, identify all the elements, identify all the steps, give meaning to all the steps, give meaning to all the elements. How do we give meaning? We can refer to patent specification. We can refer to prosecution history. What do you mean by prosecution history? The entire communication between patent applicant and the patent office, which took place during the process of patent grant, will constitute patent prosecution history. We will refer to that also. What did the applicant communicate with the patent office to understand the nature of claim, scope of that claim? We can use prior art, we can use scientific dictionaries, but this is the order in which you will rely on all these to understand what? The claim. First thing is to understand what is plaintiff's invention. The same thing we did in copyright. First thing was to understand what is plaintiff's work. Second thing is to see whatever defendant has done is infringement or not. Same is the case here. We are trying to construe plaintiff's claim to understand what is his invention, what are the steps in his invention, what are the elements in his invention. We will rely on the description part of the application only when the claim is ambiguous. The claim itself is not clear. Usually ordinary meaning shall be given to the words, and we will be interpreting claims from the point of view of person skilled in that art. If it is a invention related to biochemistry, we will have to examine it, interpret it from the point of view of somebody who is skilled in the discipline of biochemistry. And there is a caution, never rely on the title of the invention while trying to examine the scope of claim. So, first step is to understand plaintiff's claim, plaintiff's product, plaintiff's process. Once that is done, then comes the stage of claim comparison, second step. How do we compare? Comparison is done between plaintiff's product and defendant's product, claim by claim, element by element, step by step. And if all the elements of one of the plaintiff's claim is found in defendant's product, if all the steps of one of the plaintiff's claim is found in defendant's process, it is a case of literal infringement. And if that is not the case, it may be a case of infringement by equivalence. So, therefore, in step 2, if literal infringement is proved, my inquiry is over. But if literal infringement is not proved, If it comes out that defendant's product is slightly different from plaintiff's product, then we will have to go to step 3, to see whether by equivalence defendant's product is infringing or not. And this step is required only if it is proved that it is not a case of literal infringement. A product or process would be infringing by equivalence if it is in substance equivalent to patented invention. If defendant's product does the same thing as plaintiff's product in the same way to achieve same result, even if there may be some variant, it is nothing but infringement by equivalence. There are two questions which need to be answered, question number 1 and 2. I have already mentioned that there is a variant in defendant's product. We have to examine that variant. The question number 1 is, does the variant have a material effect on the way the invention works? Your product has something which is different from my product. Does that variant affect the way the invention works? If it really affects the way the invention works, it is a significant variation. That variant itself may be a different invention. But if the variant you have introduced is not affecting the way my invention works, then this variant is nothing but a colorable variant, a minor variant, and therefore it is nothing but a case of infringement by equivalence. So this is question number 1. Does the variant affect the way in which the invention works? Second question, if the variant does not affect the way the invention works, if the variant does not have any material effect on working of the invention, then the second question is, was it obvious on the date of publication of plaintiff's invention? Try and understand this point. I have invented which is rectangular, you have invented the same thing, your product is same with a circular top. Is it affecting the way the tables work? No. If it is not affecting the way the tables work, then the second question is it not an obvious variant? When my application was published on that day, go back to on that day and ask this question, is it an obvious variation? Because you see, when I claim patent on a product, my patent covers that product and all its obvious variants. So if your variant was obvious to a man skilled in the art on the date when my patent was published, then that variant is very much covered in my patent. And having such a variant would mean infringement by equivalence. So you construe my claim, compare the two products claim by claim, element by element, step by step. If all the elements of one claim are similar to defendant's product, infringement, literally infringement. If there is a variant, there is something different, see whether it is an equivalent or a new variant, a material variant. And that exercise can be done by answering the two questions which I just presented. Does the variant have a material effect upon the way the invention works? If the answer is yes, the variant is outside the scope of the claim. Second, would the variant having no material effect have been obvious at the date of publication of the patent to a reader skilled in the art? If the answer is no, the variant is outside the claim. Both these questions are question of facts. The next issue is infringement by a patent holder. Holding a patent does not absolve a person of liability for patent infringement of another patent having an earlier priority date. You see, I am talking about a situation where there are two patents on related inventions. There is a possibility of overlapping of rights in such cases. My invention, your invention are somehow related inventions. There is a possibility of overlapping of rights. Now, if I exercise your rights, I am infringing your rights. If you exercise my rights, you are infringing my rights, but there is an overlapping area. What will happen to that overlapping area? The point is very clear. In such situations, rights of one with later priority is subject to rights of one with earlier priority. We give preference to those who have earlier priority, who were first in filing the patent application. So, there may be a possibility of overlapping of patent rights, but that is to be resolved by reading the subsequent patent subject to the earlier patent. Now, there are some preliminary points. Which court will have jurisdiction to entertain the cases of infringement? As I have written, section 104 talks about jurisdiction. It says, court of district judge shall have jurisdiction. Court of district judge shall also include those high courts which have ordinary original jurisdiction. For example, there are 5 high courts which have original jurisdiction: Delhi, Calcutta, Bombay, Madras and Shimla High Court. These 5 high courts have original jurisdiction. The pecuniary jurisdiction of district court in these 5 places is not unlimited. Beyond a certain limit, the case will directly go to high court. So, therefore, court of first instance is court of district judge. A court inferior to court of district judge cannot entertain a matter of infringement of patent rights. There is another point which I would like to mention. In case there is an infringement proceeding going on, the most obvious response from the defendant is, listen to me carefully, in case there is an infringement proceeding going on, the most obvious response from the defendant is that he will raise a counter claim of revocation of patent. The defendant will say, he will raise a claim that the plaintiff's patent itself is bad and should be revoked. There are grounds of revocation. We will talk about grounds of revocation in the next lecture. So, if there is a counter claim for revocation of patent, the matter will be referred to high court. So, therefore, court of district judge, including those 5 high courts having original jurisdiction, shall be the court of first instance. However, in case of infringement proceeding where the defendant raises the counter claim of revocation, the matter will be referred to the high court. Who can sue? Who can file the case? The patent holder can file the case. His assignee can file the case. There are 2 more situations, 2 more cases. Whether exclusive licensee can file, whether compulsory licensee can file. Law says a licensee can file if he is an exclusive licensee. Exclusive license means I have granted license to one individual excluding all others. Even I am excluded from exercising those rights. Such a license can be called as exclusive license. An exclusive license can also file a case of infringement for any act done after, obviously, the date of license. If the patent holder does not cooperate, you see, I have given you the license, exclusive license, and a third party is disturbing you, committing infringement. And suppose I am not cooperating with you, or I am not joining you as plaintiff, then in that case, I will be added as one of the defendants. If the owner is not helping the licensee, he is actually helping the defendant, he is helping the infringer. So, in that case, owner, patent holder will also be made one of the defendants. Whether holder of compulsory license can file? Yes, he can file, but first of all, he has to request the patent holder to stop the infringement. If the patent holder does not take any action within 2 months, then in that case, the compulsory licensee gets the standing to file a case. Now, once infringement is established, what shall be the consequences? Will the court award damages? Will the court grant injunction? Will the court straight away come to remedies? No. There is an intermediate stage of defenses. Once the infringement is proved, there are defenses available to the defendant. What are these defenses? I already mentioned that rights are subject to all other provisions. So, defenses are no less important than rights. If I can prove that whatever I was doing falls under section 47, whatever I was doing falls under section 107 capital A, then my act, although infringing, will be exempted from liability of infringement. Section 47 provides you 4 instances, examples of defenses. The first is exemption for government use. Government is using my invention, government is committing infringement, but government is exempted from liability if government is using merely for its own purposes. And government can manufacture, government can import and give it to its departments. The government departments can do it, government officers can do it for carrying out their functions, for carrying out their duties, for performing their functions. So, if government department, government officials are using my patent for their own purpose, for discharging their responsibility, they are exempted under section 47 subsection 1. Now, the question is open whether if the government is outsourcing some activity, should that independent contractor also be given this exemption? That point is still unsettled. So, first exemption is in favor of government. It is infringing my patent rights. Second is again government use of medicine and drugs. This is related to patents in medicine and drugs. Here government can import a patented medicine or drug without liability if government is doing it for its own purpose, or if government wants to distribute it in dispensary, hospital, medical institutes of the government, or being run on behalf of the government. Not only that, government can import and distribute to dispensaries, hospitals, medical institutions which are not run by government but are declared or recognized by the government to be performing public service. So, even private dispensaries will be covered if the government has notified, has recognized, has declared that the private dispensary is performing, is discharging public service. So, second exemption is in relation to government use of medicine or drug. The third exemption is experimental exemption, research exemption, exemption in favor of educational use. If you recall in copyright, we discussed section 52(1)(I), 52(1)(H). These were exemptions for educational purposes there. You also have 52(1)(A), which also talks about fair use exemption in favor of research. So, the third point is, the third clause is exemption if I am using your product for doing my experiment, for doing my research, if I am using your invention in the course of imparting education, I am exempted from liability. The fourth one is important, it talks about use for government approval. This is an important exemption. The use of a patented invention for the purpose of acquiring government approval is exempted from patent infringement. We have this clause in section 107 capital A. Let me explain this point. So, government use exempted, government use in relation to drugs and medicine exempted, research exemption, exemption for educational purposes. These are the 3 exemptions. The fourth is, if I am using your invention to generate information which I will be using for the purposes of getting approval, manufacturing approval, then I am exempted from liability. See what happens if I am the inventor, you are a drug manufacturing company, you cannot start manufacturing the drug unless you have the permission of Drug Regulatory Authority. Now, if you want to take permission of Drug Regulatory Authority in any country, if you want to take approval of Drug Control General of India, you will have to conduct certain clinical trials, stage 1, stage 2, stage 3 clinical trials, testings, generate information, submit that information to the regulatory authority which will grant you approval on the basis of those information. Now, in order to generate that information, you will be using my invention. Now, should you first of all come to me, take license and then start using my invention for generating information to get regulatory approval? And what will happen if the regulatory approval is denied? You don't get the permission to manufacture it. What will you do with the license which you have procured from me? So law creates a solution to this problem. Law says anybody can use patented invention so as to generate information which is required to get regulatory approval. And once approval is granted to you for manufacturing, you can come to me and negotiate a license with me. Who is at loss? Yes, inventor is at loss because inventor would have demanded money equivalent to the remaining period. So if 3 years will go in obtaining the approval, I am left with 17 years or less than that. So I will be able to negotiate only with respect to the remaining period of time. So I am at loss. That is the mechanism which Article 30 creates. Article 30 of TRIPS agreement creates. Article 30 of TRIPS agreement talks about exemptions, talks about defenses. And it says in no case the loss must go to the users. So therefore, if at all there has to be some loss, it must be given to the inventor. That is what Article 30 creates, the mechanism which Article 30 creates. Now, it has come from a case called as Roche Products Incorporated versus Bowler Pharmaceutical Company Incorporated, and this exemption gets its name from this case. Such an exemption is called as Bowler exemption. Court in this case, the American court of in this case in the year 1984 says, any company that manufactured, used, sold, offered for sale or imported a patented drug or a biological material is exempted from patent infringement liability if such an activity is meant for development and submission of information to Food and Drug Authority for getting approval. Such an exemption is called as Bowler exemption. The American Bowler exemption is applicable only with respect to two kinds of inventions. One is invention related to drug, the other is invention related to biological material. So if I am using your invention so as to generate information to be submitted to regulatory authority for getting approval, I am exempted from the liability of infringement, although I am committing infringement. This is Bowler exemption. This Bowler exemption finds place in Indian law in section 107 capital A clause A. And my Bowler exemption, the Indian Bowler exemption, is not only limited to drug only. It is for any kind of invention, invention relating to any subject matter. So if therefore I want to manufacture some telecom product and I will have to get the approval of telecom regulatory authority, I am free to use anybody's invention so as to generate information which I would be submitting to telecom regulatory authority to get approval. So my provision goes beyond the American Bowler exemption in terms of the fields to which it relates. It is not only limited to drugs and biological material. Second point is, I am free to send information not only to Indian regulatory authorities. The exemption applies even if I send the information to foreign regulatory authorities for getting approval to manufacture the product in their jurisdiction. So that is how Indian provision is a wider provision. This is the fourth point which we have in the list of exemptions. First three are covered in section 47. Fourth is covered in section 107 capital A clause A. The fifth in the list of exemptions is called parallel import. Let me explain this point. I have explained what is infringement, literal infringement, infringement by equivalence. Once plaintiff is successful in proving that defendant's act is infringing, what is left with the defendant? He will have to prove that his act falls in one of the defenses, one of the exemptions. 47 lists certain exemptions. 107 capital A clause A identifies Bowler exemption. As I mentioned, Indian Bowler exemption is wider than American Bowler exemption, and the name comes from the case in which for the first time an American court establish this exemption. The fifth exemption, the fifth defense is called parallel import. This is a situation where I am importing a product from some other country, a patented product is imported from some other country, by lawfully acquiring it from a person who is authorized to sell it in that country. You see, there is a patented product which happens to be costly in India, suppose. The patented drug is costly in India, and I want this drug which I find is relatively less costly in a country, for example, Brazil. What I can do, I can go to Brazil, purchase it lawfully from a person who is authorized in law to sell it there, import it into India and sell it in India in the form of a trade channel which is a parallel trade channel. If I am doing it, I am infringing. I am infringing because right to import is an exclusive right given to the owner of patent holder, owner of patent rights. Right to import, as I mentioned, if you go back to section 48, right to import is an exclusive right of patent holder. No one can import without the consent of patent holder. But I am talking about one kind of import which is, although infringing, is exempted from liability. What is that kind of import I am talking about? Where I am importing the patented product after lawfully purchasing it from a person who is authorized under law to sell it there in that country, then in that case I am exempted from liability. Now, if you see what I have written here, parallel import means the importation of a product from another country without the permission of patent holder. Because it is done without the permission of patent holder, it becomes infringing. It is infringement, but it is exempted from liability. Why? Because you have legally purchased it from somebody who is authorized person in that country to sell. If these conditions are fulfilled, you are exempted from the liability of infringement. And this exemption is contained in section 107 capital A clause B. If you recall, we have studied something similar to it in section 14 of Copyright Act. This is based on the principle of exhaustion of rights. Once sold, the rights will exhaust. You may refer to the idea of national and international exhaustion of rights, which we discussed in relation to copyright law. But the point here is, it is based on the principle of exhaustion doctrine. Once I go to Brazil, purchase it from there, the person who sold it, his rights have exhausted. And if his rights have exhausted, he cannot stop me from selling it in India in the form of doing parallel trade. That is what we mean by parallel import. Developed countries do not want parallel import because they see it as a loss. Developing countries consider it as an opportunity because that helps in reducing the cost of many life-saving drugs, drugs which are not easily available or which are very costly in India, can be borrowed from some other country with the help of, in the form of parallel trade. So developing countries consider it an opportunity. This debate continued, nothing could be settled. What kind of exemption doctrine, what kind of exhaustion doctrine should we have? So finally, TRIPS agreement in Article 6 says that any dispute related to exhaustion doctrine will not be entertained by WTO Dispute Resolution Forum, meaning thereby whatever the country wants, if it wants to have national exhaustion, it can continue with it. If it wants international exhaustion, it can continue with it. TRIPS does not give you a mandate. We have used it. The next defense is called Gillette defense. There is no liability if a product or process that is infringing, that product itself was not new on the date of filing of your application. Understand it this way. Your product is X, my product is Y. You are saying Y is infringement of X. If I can prove that the day your patent application was published, on that day itself, Y was not new. And if Y is similar to X means what? X was also not new. This is a situation where if you insist on infringement, you have a chance of losing your patent. This is something, you have a case, J. Mitra and Company Private Limited versus Kesar Medicaments. If you are saying that I am infringing your patent and I am saying that my product was not new on the date when your application was published, meaning thereby your product was also not new, and if I am infringing your product, there is a chance of you losing validity. This is also called as infringement validity dichotomy, and I can read it here. If you see, as the scope of the monopoly is determined by what is claimed in the patent, the applicant may be tempted to claim more than they perhaps ought. At the same time, however, applicants need to be mindful of the fact that if they draft claims too broadly, this increases the chance there is for the patent to be declared invalid. So my point is, if my product is similar to your product, and if I can prove that my product itself was not new on the date when yours was considered new, then there is a chances of you losing your patent itself. Section 107 also says that all the grounds on which a patent may be revoked, all those grounds can be taken as defenses. There are certain equitable defenses like laches, acquiescence, etc. So this is a list of 8 defenses, 8 situations where despite proving infringement, I am exempted from liability. Section 108, clauses 1 and 2 provide remedies for infringement of patent rights. These remedies include injunction, damages, account of profit, destruction of infringing product, seizure, forfeiture of infringing product. Injunction is important. It is equity based. Injunction means to do something, an order to the defendant to do something or refrain from doing something. Injunction can be permanent, injunction can be temporary. Temporary injunction is based on 3 relevant points. Plaintiff has to establish prima facie case. Plaintiff has to establish irreparable loss, and plaintiff has to establish balance of convenience. Irreparable loss means a loss which cannot be repaired by compensation. Balance of convenience means that one has to weigh the inconveniences which may be caused to plaintiff in case injunction is not granted and defendant in case injunction is granted. Weigh these inconveniences to decide whether it is a case for issuance of injunction or not. Damages and account of profit are 2 alternative remedies. You can claim either of these. Damages means the loss suffered by the plaintiff. Account of profit is the profit earned by the defendant. So therefore, and the point is, my act nowhere gives any clear guidelines as to how to compute damages. Should we include R&D expenditure which you have incurred in creating that invention in computation of damages? These are the factors which are not very clear. Generally also, we are not very good in valuation of our patents. So that is one subject which needs to develop. So damages is actual loss suffered by the plaintiff. Account of profit is the profit earned by the defendant. Punitive exemplary damages can also be claimed. Innocent infringement, in cases of innocent infringement, no damages may be claimed, however, injunction can be claimed. Section 113 says that in any proceeding before an appropriate forum, I can claim declaration of validity of my claim. There is no presumption of validity, but in any case, any proceeding, I can claim a declaration that the competent forum may declare that my claim is valid. I can also request the court to declare that my acts are non-infringing. There is a case, 3M Innovative Properties Company, in which court has discussed the point which I have already mentioned, that despite the grant of patent, there is no presumption of validity of patent. Court also said that while granting injunction, the general principles which are applicable to ordinary civil courts shall apply. There is one important point which you will find in Sandeep Jaidka versus Mukesh Mittal 2014 Delhi High Court. This relates to patent held on 4D effects. Since the patent was not utilized by the patentee directly or indirectly in commercial market, the patent holder himself never exercised rights. Court said that anybody else exercising that right would not mean infringement, and therefore plaintiff cannot in equity claim temporary injunction. If you are the patent holder on 4D effects and you are not exercising it, patent is not granted just to keep the monopoly, it is granted to be exercised. If you are not exercising, a third party can come and exercise, and in that case, in equity, you cannot claim injunction. These are some of the remedies. Now, if I conclude, in present session, we discussed infringement, defenses and remedies. Unlike section 51, we don't have any provision which talks about meaning of infringement or instances of infringement, as you have in section 51 of Copyright Act. There is one important observation before I conclude this session. There is a case called as Bayer Corporation versus Natco Pharma Limited and Alembic Pharmaceuticals Limited, 2017 Delhi High Court, in which court said that the exemptions of section 107 capital A must not be treated as a proviso. The exemptions should not be treated as proviso to section 48. Section 48 is rights of creators. Section 107 capital A is rights of users. So these are independent provisions. Don't interpret section 107 capital A in the light of section 48. So that's all in this session. In the next session, which will be the last session on patent law, we'll discuss two important aspects of patent law. One is called compulsory license and the other is called revocation of patents. So that's all in this session. Thank you very much for joining. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.